So why don't we get started? So I'm Randy Schmidt. I am the director of the clinic's Employment Law Clinic. And I'm kind of the host of this informational session on the various clinics. So welcome all of you. It's good to at least see pictures of you, even though almost all of you have your cameras off. That's fine. So what we're going to do today is talk about 4 of the litigation clinics. We're going to do the Federal Criminal Justice Clinic, the Abrams Environmental Law Clinic, the Jenner and Block Supreme Court and Appellate Clinic, and then last, the Employment Law Clinic. Each of the clinics will have about 12 minutes. I hope to be able to save some time for questioning at the end. And we're going to do the clinics kind of in the order that they appear on my list. So we'll start with Professor Siegler and Professor Miller, who head up the Federal Criminal Justice Clinic.
And Professor Zunkel.
Oh, and Professor Zunkel. I didn't see her on the list. Is she here?
Yes.
Here.
Okay. All right. Sorry.
Should we take it away, Randy?
Yes, go ahead.
Okay. So we're here from the Federal Criminal Justice Clinic. The mission of our clinic is really to address the 2 most pressing civil rights issues of our time, which are over-incarceration and racial disparities in the criminal legal system. So, in our minds, that mission is of utmost importance now, even more so than ever before, because COVID is overtaking our federal jails and prisons. Our students in the Federal Criminal Justice Clinic write very complex motions and briefs. They brief cases at all levels of the federal criminal system, both the district court, the Court of Appeals, and also petitions for certiorari to the Supreme Court. During more typical times, our students also stand up and argue in federal court in front of federal judges. And students tend to spend a full year in our clinic. We have a lot of 3Ls, but we also have space for 2Ls. So it's a mixture of 2Ls and 3Ls, and most of our 2Ls continue on into the clinic for their 3rd year as well. Our clinic is, I'll tell you a little bit about some of the things we're doing and then turn it over to the other professors and to some students. But our clinic is running right now a federal bail reform project, which is aimed at really reducing the number of people who are incarcerated and locked up in jail pending trial. These are people who are presumed innocent. The federal system has an insanely high pretrial detention rate. We detain 75% of all people who come through the system. So our clinic has been pursuing a multi-pronged campaign to combat this problem and this crisis. We ran the first court watching initiative ever in federal court in the country. We discovered through that judges and prosecutors were disregarding the bail law and detaining clients in violation of it. We also have engaged in really high-level legislative reform work. So I testified before the House Judiciary Committee a few months ago about this crisis. Our students actually did a full rewrite of the Federal Bail Reform Act, and we submitted that to Congress. And word is that some really high-ranking members of the House are interested in making our rewrite the law. So we feel like we're having real impact. In fact, Professor Zunkel and I just learned today that our rewrite and our work that we've been doing legislatively has now been incorporated into something called the HEROES Act that would release a lot more people from federal jail during the pandemic. So that's really exciting. And it's really gratifying to watch as our work changes federal bail practices nationwide. Federal judges around the country are approaching the issues differently as a result of our work. Federal prosecutors are following the law more closely, and defense attorneys everywhere are filing bail motions written by our students. I'll turn it over to, who's next? I think
me. Hi, everyone. I'm Erica Zunkel. I'm one of the professors in the Federal Criminal Justice Clinic. One of the goals of our clinic is to do cutting edge work that fills truly pressing needs in the federal criminal system. When COVID-19 hit, we knew that it would have a huge impact on our client base, people in federal jail and prisons. And we really knew that we needed to shift our focus to litigation and policy work that would help our clients. So this quarter, we decided to put some of our other projects and cases on hold, and we decided to create a COVID-19 rapid response team. The team's work has taken several different forms over the course of the quarter. As Allison just mentioned, we've worked with Congress on legislation that would release more people from federal jails, and we've helped the federal defenders nationally with their policy response. We've also really focused on gathering information about what's happening on the ground in federal jails and prisons as COVID-19 really spreads like wildfire in the jails and prisons. And then our main project has been filing compassionate release motions for people who are really vulnerable to COVID-19 because of their age and their health conditions. And one of our 3L students, Allie Van Dyne, will tell you more about our compassionate release work in just a few minutes. But to give you an overview, we took on this quarter 6 compassionate release clients in total, with each student on the COVID rapid response team assigned to one of the cases, and sometimes they were assigned in teams. Working on these motions has given the students an opportunity to really experience every aspect of federal criminal practice. So they've done really interesting legal research and writing. They've been in contact and talked to our clients and their family members and friends. They've created release plans that we can present to judges to explain how our clients are well situated to be safe and healthy outside of the prison walls. They've gathered and reviewed medical records, pre-sentencing reports, and all sorts of other court documents, and that's just a short list of the things they've done. Preparing and filing these motions on such a short time frame has been a challenge for all of us in the clinic, but a wonderful challenge. And as we knew they would, our students have stepped up in an absolutely huge way, have been really wonderful advocates for our clients as the pandemic continues to rage on in federal jails and prisons. And thanks to our students' advocacy, several of our clients have been released, and we hope the remainder will be released very soon. So I'm going to turn it over to Allie Van Dyne to tell you more about one of the cases and clients that the FCJC has been working on this quarter.
Hi everyone, I'm Allie Van Dyne and I'm a 3L. As Professor Zunkel mentioned, the FCJC has been working extremely hard to research, write, and file compassionate release motions for vulnerable people who have already been convicted and sentenced and who are now in Bureau of Prisons custody across the country. I have the honor of working on the case of a client I'll call Fred. This case has given me an incredible opportunity to work directly with a client and his family and to work on something meaningful. So federal compassionate release, just for people who don't know, because they don't teach it in Crim 1 or 2, permits a judge to reduce a person's sentence for medical reasons, family circumstances, or other sort of extraordinary and compelling reasons. By a stroke of luck, that federal compassionate release was just expanded by Congress as part of the First Step Act and then as part of the CARES Act a little bit as well. So incarcerated people can now bring these motions before federal judges directly instead of relying on the Bureau of Prisons to just let them go home, which was always sort of an interesting premise that is crazy. So the FCC on 6 clients in this effort, and we worked with Professor Zunkel and Professor Siegler to contact clients and their families, to work out a legal strategy, and to write the motions for compassionate release. And like Professor Zunkel said, going through a lot of documents, I had never really gone through medical records before, but that's something I know how to do. But as we worked on this, developing the strategy, I was surprised by how much knowledge I had soaked in from my work through the year that then I would turn around and use to spread. So doing all this on such a short timeline has raised several challenges. Some teams are able to get in touch with our clients and their families weekly. That my team was one of those teams. And this helped us get really important information that helped us tell a more compelling story to the judge about, who our client is and why they should be released. Others had more issues, and so to resolve those, we meet once a week as a team to brainstorm ideas and talk through problems. So my client, Fred, he was convicted of his first ever offense, transporting drugs, at the age of 67. He was sentenced by Judge Shaw here in the federal court in Chicago to 36 months prison, which was below the guidelines, the sentencing guidelines, recommended for that crime, but still a really long time when you're 57. So his age, along with serious health conditions like high blood pressure and diabetes, made him really vulnerable to COVID-19. And fortunately, COVID-19's not yet in his prison that we know of. Wanted to get him harm's way before it's too late, because in the Bureau of Prisons, it's only a matter of time. At his specific facility, the virus was already in the surrounding community. So moved really quickly. We've got our opening brief and our live brief exactly 1 week apart, so that moved very fast. Unfortunately, Judge Shaw did deny our motion, and sometimes you'll lose and how to immediately pivot to advocating for your client in a different way that hasn't been foreclosed. It's like an incredible skill that I've learned. But the following day, actually, after our motion was denied and we were kind of sad, we actually learned the Bureau of Prisons separately, part of a different track, granted our clients to be released to home confinement to serve the rest of his sentence, which he'll be able to serve the remaining year or so on his sentence. His daughter living with her was much better than being in prison. And from what we understand, he actually went home to Adina yesterday. So that's great. Learned so much from this experience that you don't usually learn in law school. I saw how much institutional trust courts have in the Bureau of Prisons would call earned, even in the face of a lot of objective facts about how badly the Bureau has mishandled COVID-19. And I felt the sting of hearing the prosecution and the court talk about your client in a pretty humanizing way, which when you're reading cases, it just doesn't hit you the same way. Example, the government tried to argue that Fred, who has serious medical issues, would be safer in prison than at home with his daughter, and that argument just felt like a slap in the face, honestly. But learning how to roll with those punches and the importance of empathizing with your client is so powerful, and I feel like law school doesn't really teach you that, even though it's really important to successful legal practice. And just to wrap up, I've loved my time at FCJC. I'm really glad I graduate. This is such a unique clinical opportunity that doesn't exist other places, and so fast I couldn't have learned elsewhere. And so if you're interested in federal criminal reform, engaging in hands-on work, this is definitely the clinic for you. And now I'm going to hand it off to Alex Aparicio, my colleague.
Hi, everyone. My name is Alex, and I'm a 2L. Right now, I'm working on the clinic's COVID project, but I'm going to speak very briefly about our clinic's bail reform project and my experience with that. So Allison spoke a little bit about how the bail project was formed and our experience with the court watching initiative, which is how I first became involved. And the scale of that court watching was immense. Over a 10-week period, we watched nearly every bail-related hearing in the Northern District of Illinois. And for me, court watching was a great introduction to federal court because I got to know every single magistrate judge. I saw cases ranging from drug conspiracies to illegal reentry to postal fraud, and I was even there to collect data on R. Kelly's detention hearing. But I also saw a lot of violations of the Bail Reform Act, which is the statute that governs bail decisions. The U.S. Attorney's Office would frequently argue for detention on grounds that weren't authorized by the statute. The defense might not object, and even worse, the judge might not catch the mistake either. So by the end of the 10 weeks, it became very clear that the statute, because it was so confusing, because it was not being used in practice, needed a ground-up rewrite. And I was fortunate to take the lead with that project. It was extremely daunting at first because for every change we were making, we needed to draw support from our data, from data collected by other people. We needed legislative history and legal precedent. And then the changes themselves that we were making needed to be thought all the way through, and we needed to debate and discuss each word that we were going to be changing in the statute. The final bill that we produced and the accompanying 50-page report was a labor of love. And as Allison mentioned, it's been getting a lot of attention in the House, and we're hoping to see it passed very soon. To have done that kind of work and receive national attention as a 2L is really amazing. But I'm proudest of the work that the clinic as a whole has done to move the conversation on bail forward. And I'd just like to say that our bail reform project is ongoing, and we need some fresh minds to help us advocate for change. So if any of you are interested, I would love to work with you next year. And if we have any more time, I think I'll turn it to Professor Miller.
Actually, I think I'm going to have to cut this short. I'm trying to get all the clinics in. So thank you to the Federal Criminal Justice Project. At this point, we will move on to the Environmental Law Clinic with Professor Templeton and Professor Weinstock, I believe. I see nods.
Yes, great.
My video is still working. That's good.
Great, thank you, Randy. And I am going to try to share a PowerPoint here, just a handful of slides. And I hope, it looks like folks can see it. Great. I'm not seeing any head shaking. I'm seeing general nodding, so we'll presume I did that all right. So great. So I'm Mark Templeton, and with Rob Weinstock, we work on a series of environmental and energy challenges that are facing Chicago, our region, the country, and the world. And we do that through both litigation and advocacy. And what I'm going to do today is, in the first portion of this, just tell you a little bit about what our approach is and who we work with. We're then going to shift to two case studies. So one related to energy justice and renewable energy in the Detroit area. And then a second project in Northwest Indiana, where we're fighting against basically cancerous release of toxic substances into Lake Michigan that affect our clients. And while we are really committed to advancing environmental energy issues, at the end of the day, a lot of this is about people. So we're going to talk to you about our clients because they're so critical to what we do. So again, our mission is to solve some of the most pressing environmental and energy challenges. We think of energy these days as being integral to environmental work. And this describes our approach. I think what's key to understand for people outside of this is that under some of the core environmental statutes, if the government is not enforcing the law against the polluter, right? If someone is putting, or a factory is putting too much pollution into the water or the air or contaminating a site, the soil, citizens have a right to get involved. Affected citizens can sue the polluter or they can sue the government. And so that is what we do. We also try to work with government to come up with better solutions so we don't have to have suing as the only line of defense, and actually to incentivize companies to do the right kinds of things as well. This is also true in the energy domain, where if people are affected by changes, they can get before courts and administrative bodies as well. We have a huge variety of clients and partners. I would summarize this by saying we work with the top environmental organizations in the country, either as representing them, right? So we're lead counsel or have them as co-counsel, or as those include Sierra Club, Natural Resources Defense Council, Environmental Defense Fund. We work with regional organizations, and we work with some grassroots organizations that frankly don't even have logos for us to put on the screen here. So we're working at all levels across these issues. Our projects generally fall into, I'd say, 5 buckets. So one is about climate change and renewable energy. We had students just a couple of weeks ago file an amicus brief in the litigation challenging the Trump administration's rollback of regulation of greenhouse gas emissions from coal-fired power plants, right? This has a huge impact on climate change and the environment and the economies. And students represented a world-leading economist on filing an amicus brief in the DC circuit. In environmental justice, we work closely with a community about 15 miles from Hyde Park in East Chicago, Indiana, just on the other side of the border. There are 2,000 people who still live on a highly contaminated Superfund site, contaminated with lead and arsenic in the soils, lead in the drinking water. There are proposals to redevelop part of the area, which on the one hand would bring economic opportunity, but we think that there are not enough environmental protections for the people who are going to be living there when the remediation and operations of the business take place. Rob's going to talk in just a minute about one of our Clean Water Act projects. It's just one of several that we have related to enforcing the Clean Water Act when the government is not doing it. I'm going to talk in a second about our energy democracy work. And then we also have some projects related to endangered species protections. So turning to our two examples, I'm going to talk first about our representation of solidarity, which is, and then Rob's going to talk about our case on behalf of Surfrider against US Steel. Solidarity, I might as well just jump right to this. Again, the first is kind of energy democracy and renewable energy. The second is about Clean Water Act protections. So in terms of the work with solidarity, you'll see on the left a logo of DTE Energy. That is the $10 billion utility company that provides electricity in southeastern Michigan into the Thumb area as well. That logo on the right is Solidarity. You could, I should have put beneath this Goliath on the left and David on the right? Because DTE has resources hundreds of thousands of times greater than our client Solidarity. Let me tell you where Solidarity is and what they're working on, and then I'll explain what our advocacy and litigation has been. So Solidarity is based in a community called Highland Park, which is that little red shape there. That is a community entirely surrounded by Detroit, and you'll see it in Michigan. And Highland Park is a community of color. It's a low-income community. And what happened was that many of you may be aware that Southeast Detroit, Southeastern Michigan, Detroit, and various suburbs have struggled financially over the years. About 10 years ago, DTE, the monopoly utility, repossessed the streetlights in this low-income people of color community, repossessed 1,000 streetlights, depriving that community of this vital public service. Admittedly, Highland Park had trouble paying its bills, but taking away the lighting is certainly not going to help the situation there in terms of trying to improve the community's situation, security, economic prospects, et cetera. So Solidarity was founded to actually set up solar streetlights and to advocate for the Highland Park community. And here you see some of the energy advocacy taking place, right? People protesting against unjustified rate hikes by the utility that would disproportionately impact low-income customers. When we started to dig into this, we saw rate increases 10 times as great in percentage terms as they would be for middle and high income individuals. Service is terrible, down lines, more injuries and deaths caused in Detroit than other parts of DTE service territory. And the community was really looking for economic development in terms of this investment in renewable energy and energy democracy, where people could actually invest together in solar panels and really get not just the renewable energy benefit, but also a real economic driving force in the community and a political organizing kind of effort as well. So what did we do? In Michigan, as in many states, there's an administrative body that actually regulates the utilities like DTE. And so this is actually the hearing room at the Michigan Public Service Commission in Lansing. And that is, we have students who basically represent Solidarity in these hearings and litigation before the Michigan Public Service Commission there, but literally in that room. So what we have advocated for on behalf of Solidarity is a faster transition to clean energy, greater access for solar, particularly in these areas like urban areas where you might have renters or multi-unit owners. So not your kind of traditional suburban single-owned owner house. We've advocated for including distributed solar energy and actually the way that they think about these issues and investments in reliability and safety in these low-income areas. Students recommend strategy to the client. Got an email from the client last night saying, hey, can you help me? I've got this upcoming meeting with somebody. Need some quick turnaround, right? We are that kind of go-to access for our client. We've gotten into discovery fights. Students have drafted testimony for our client and expert witnesses. Students conducted cross-examination, multi-hour cross-examination on the record before the administrative law judge of high-level utility executives, and done a ton of legal research and writing as well. And we've scored some real victories as well in terms of what the commission is requiring in terms of upgrades, pushing back on some of the bill pilot programs and other efforts to promote renewable energy. I'm going to turn in the remaining 2-3 minutes we have to Rob to talk about our clean water work.
Great, thanks, Mark. So I'm Rob Weinstock. It's really a pleasure to be here with everyone today. I'm going to try to speak quickly about one of our Clean Water Act cases, Surfrider versus United States Steel Company. What I like about this project, I like many things about this project, but one thing that's great for today's presentation is that it really covers a range of different advocacy techniques that we use in the clinic and has evolved over time to really demonstrate a lot of what we do in different contexts. So what you see on the screen here is proof, photographic evidence that people do surf in Lake Michigan. They surf when the rays of sun shine through the clouds, they surf in the winter. If you see that top right-hand picture with ice in the foreground. In the background of all these pictures is the industrial corridor of Northwest Indiana, where US Steel has two large facilities, one in Portage, Indiana, that we'll talk a bit more about. Mark, you can go to the next slide, please. Okay, Surfrider contacted us almost 3.5 years ago, and they wanted to know what was in the water where they were surfing. So you see those two beach icons, Whiting and Portage. Those are two of the best freshwater surf spots in the world, certainly in the country, at the bottom of Lake Michigan, where the wind whips down the lake and creates great breaks against a lot of the industrial infrastructure on the shoreline. So that's where they surf. You see the US Steel Portage plant on the right side of the screen. That's the one we're going to talk about. But we started this relationship by asking that question, is it safe to surf where we surf? So we dug in, we submitted FOIA requests. We started really what was going to be a policy project. Are the water quality standards strong enough? Are they being enforced? What can we do to get regulators to do their job to protect these beautiful places, these special places where people are in the water? You can go to the next slide, Mark. That shifted dramatically in April of 2017 when that Portage facility of US Steel's dumped about 300 pounds of hexavalent chromium, which is sort of the chemical made famous by the Aaron Brockovich movie, dumped it into Lake Michigan from a ruptured pipe and causing the closure of beaches, public drinking water intakes, and even threatening the city of Chicago's public drinking water intakes some 30 miles out into the lake. So our clients immediately said, okay, this policy work is great and it's important, let's keep thinking about it, but we need to pivot and focus on what's going on at this beach. What you can see in that picture in the top of the screen is actually the facility is in the top right corner, and across that little piece of canal, that what's called the Burns Waterway, is the Portage Lakefront, which is now a part of America's newest national park, and is that surf spot what you saw on the other slide. So you literally are about 40 yards from the pipe where all this hexavalent chromium was discharged. You've got a national park and a beach where people are jumping in the water. We filed our suit after extensive pre-complaint investigation. We filed our suit in January of 2018. The federal government, state of Indiana, sort of came along after in April of 2018, filed their case, and on the very same day proposed to settle their case with the company. We've been fighting ever since to make that settlement and any resolution to these two pieces of litigation more robust. You can see some of our goals there at the bottom of the screen. I recognize we're coming up on time, Mark, so why don't we just jump to the next slide, and I'll talk a little bit about all of these words. It's a lot here because we've done so much in 3 years. These are things that students have done themselves in terms of litigating and really piloting two complex federal cases through the court in Northern District of Indiana, filing complaints, various procedural motions, a massive summary judgment style opposition with hundreds of pages of expert affidavit and client affidavits. Most recently, we just filed a supplemental brief talking about how a Supreme Court case that came down 4 weeks ago actually impacts our case and supports our position that the government's proposed settlement is too weak. And that's the sort of cutting edge work we've been able to do here, is really applying ongoing and emerging legal developments to this case. That also applies to policy developments under the current administration that have rolled back certain policies, both at EPA and the Department of Justice, that impact our case. We've been analyzing them in real time, getting that information to our client, Surfrider Foundation, to help not only with the advocacy campaign in Indiana, not only with our case, but also with their work nationwide. I guess I'll turn it back to Mark for just maybe 2 seconds of concluding remark, but I really do appreciate the opportunity to be here and encourage you all to reach out if you have any questions about what it's like to practice in a complex regulatory environment like we do.
We've got a web page, more information, nice video. Thank you. Would love to put you in touch with any of the students who we have worked with. Would love to have you join the clinic. Thanks so much.
Okay, thank you, Mark and Rob. The next project we're going to hear from is the Supreme Court and Appellate Clinic. Sarah?
Hi, I'm Sarah Konsky. I'm one of the 3 directors of our Supreme Court and Appellate Clinic. I teach this clinic together with David Strauss from our faculty and Matt Hellman from the Jenner and Block law firm. As you probably guessed from the name, our clinic represents clients in Supreme Court and appellate cases. On the U.S. Supreme Court front, since we started our clinic in 2016, we've been co-counsel for parties in 7 Supreme Court cases. We've filed a lot of amicus briefs and petitions for certiorari. We've also represented parties in a number of Seventh Circuit cases. Unlike some of our other clinics at the law school, we're not focused on a particular subject matter or advocacy issue. So we work on a wide variety of pro bono issues, and our cases in recent years have covered everything from constitutional law issues to criminal law to habeas corpus to remedies. We endeavor to give our students hands-on experience in appellate advocacy. As you'd probably guess, it's research and writing intensive, and our students do a lot of writing and editing on our briefs. We also spend a lot of time thinking about strategy and analysis to help sharpen our students' lawyering skills. For students who hope to be appellate advocates, we think the clinic is a great foundation and launching point for developing those skills. But more generally, we see the clinic as a great way to work on skills of general applicability. So our students are analyzing complicated legal arguments, working on writing persuasively, thinking about how to be thoughtful and strategic in their advocacy and the like. So with that introduction, I wanted to turn it over to 2 of our current 3L students, Addison Bennett and Andy Osborne, to talk a little bit more about their experiences.
Yeah, thanks, Sarah. I see that I misspelled my name. That's good. It only has 1 S. But anyway, so I'm going to talk a little about the Seventh Circuit work that we do and the circuit court work that we do. And Addison, I think, is going to focus a little more on the Supreme Court level work, mostly at a high level of generality, but happy to talk about this in more detail with anyone who's interested in the clinic. So in our clinic, as Sarah said, we focus sort of on both levels of federal appellate courts. So most of our work in the appellate courts is focused in the Seventh Circuit. I personally have actually enjoyed that work more. I think the Supreme Court work is fun and great, and it's a little like sexier maybe, but I really enjoyed the Seventh Circuit work because it's very student driven, and we've been able to work in teams. And our students also argue before the Seventh Circuit. So when I was a 2L, I was on sort of the team that was helping with the briefs and also with the argument for one of the 3Ls at the time to argue in the Seventh Circuit. That was probably my favorite experience in the clinic and we were able to actually get a very favorable result. It was a case where a prisoner had filed a Section 1983 civil rights claim. He was legally blind. He had trouble litigating. He had tried to move for appointment of counsel several times, and the district court sort of cursorily denied those motions. And we were able to obtain a precedential opinion from the Seventh Circuit that basically added more protections and more hurdles that the district court has to go to. And we got a remand with instructions to appoint counsel for our client. And then this year, I was able to argue the case in front of the Seventh Circuit. And that was also just an incredible experience because I was able to work with members of the clinic, clinical faculty who mooted me, our faculty, other faculty members who mooted me. And it was just a crash course in learning how to be an appellate advocate. And it was a tough panel. It was a really sort of complex case. I won't really get into the details because it's we started working on it, I think, 4 or 5 years ago, and it was a habeas case, and there were several sort of layers to it, but we were able to get dismissal of the government's appeal when the government was basically trying to get charges reinstated or to have our client sentenced on charges that were dismissed pursuant to a plea agreement. Again, it was sort of an odd case, but and really sort of challenging, but being able to work on it with other students in the clinic was probably the best experience I've had in law school. And so I've really, again, liked the Seventh Circuit work, but the Supreme Court work is really fun too. And Addison's going to talk a little more about that, but I'll just say, I'm happy to talk in more detail with anyone about the clinic specifically. But I would just encourage anyone to do a clinic if you're interested. Because I think, especially if you're 1Ls, you hear a lot that, you're learning how to think like a lawyer, whatever sort of that means. But I think the clinics are what teach you how to be a lawyer. At least that's how I feel. And I feel really lucky to have had the opportunity to work in this clinic. So without further ado, I'm going to pass it over to Addison.
Yeah, thanks, Andy. Hi, everyone. So I, like Andy said, will be focusing more on the Supreme Court side of the Supreme Court and appellate clinics work. But I would also very much echo what Andy just said about one great aspect of the clinic is our Seventh Circuit work because it is so student-driven. And that really has been fun. And the appellate advocacy can be sort of abstract and feels a little more like law school sometimes, but in our Seventh Circuit advocacy, sounded like I said something being like law school is an insult. I didn't mean it that way. But in our Seventh Circuit advocacy, we do get to meet clients and show up in court. And so it's not entirely abstract and academic. So our Supreme Court work, sort of shifting focus there, really sort of breaks down into 3 categories. We do get the occasional, Andy and I have both been in the clinic for 2 years now, and each year we've had a handful of merits representations where sort of along with the attorneys at Jenner and Block, we have essentially been on the briefs as co-counsel in Supreme Court merits cases. And without getting into the weeds too much in any of those cases, some recent ones have included issues of administrative law, and if people are following the pending Supreme Court cases, we have been involved in sort of the various iterations of the previously Carpenter versus Murphy and now McGirt versus Oklahoma case about the status of Eastern Oklahoma and whether all of that land is a tribal reservation subject to, as relevant to this case, different sets of criminal laws. Andy and I, along with a few other students, actually got to go to the Supreme Court and see the argument for the first round of argument last fall, which was in many ways a fun field trip, but also a very valuable academic experience of sort of seeing the work we had put into doing the research and helping the attorneys think through that case come to life and to see all the justices sort of grapple with it. Was a very rewarding experience and also very, very enlightening. So we do get merits representations, and we're very much a part of the team on that in terms of the research and writing and the oral argument prep. We participate in the Supreme Court litigation in a couple of other ways. We are almost always working on an amicus brief or two. representing various clients from nonprofit organizations to, well, all sorts of clients, really. We've worked on immigration cases, on criminal issues. And as Sarah said in her introduction, our clinic, one of the advantages of it and one of the fun things is we don't have a specific subject matter focus. So when a case first comes to us, we're often just trying to get our head around the issues. And when we're working on an amicus representation, it's a fun interaction of wrapping our head around a complex Supreme Court issue while also doing our best to advocate for the client's interests in a way that presents the issue in a way that the parties arguing the case might not present it. So it's an interesting, again, interaction of sort of advocacy and sort of getting our minds around the academic side of each case. So that's been really fun. And sort of the final piece of it is working on petitions for cert. All of us in the clinic are assigned various federal circuit courts to sort of monitor throughout the year, which is a fun experience. So over the course of being in the Supreme Court and appellate clinic, you end up reading a lot of circuit court opinions and sort of keeping an eye out for potential good cases and vehicles to be brought up to the Supreme Court, which obviously is a challenge given how few cases actually make it up to the Supreme Court. Sometimes we feel we have a great candidate for cert, and other times it's just a really interesting learning experience to see sort of what the circuit courts are up to. So we really do sort of have our hands in all sides of Supreme Court litigation. One of the most fun and interesting pieces of it is when a case first comes to us, we as students are very much on the team, just sort of wrapping our head around, okay, what's going to matter to the justices? What's going to matter to the specific justices we think might be a swing vote in a particular case? What's complicated about a case? What's easy? What's the hook to best represent our client? So in those cases, we very much feel like part of the team. We've all written words that have found their way into Supreme Court briefing, and it's been on the whole a very rewarding experience. And like Andy, anyone who's interested should please feel free to reach out to me.
Thanks. If you have any further questions about the Supreme Court and Appellate Clinic, don't hesitate to call or email. I'd be happy to chat further.
Okay, thank you. So the last clinic we have is the employment law clinic, but before we do that, because I was concerned about time, I wanted to go back to Judith Miller from the Federal Criminal Justice Project to give her a moment to introduce herself. And yeah, I think we'll still have some time for questions. Go ahead, Judith.
Hi, everyone. I just wanted to say I'm Judith Miller, the third faculty member in the Federal Criminal Justice Clinic. And I know we're really short on time, so I'll just leave it at that, having heard so much from really extraordinary work that Allison and Erica and Alex and Allie have been doing. But I too have been blown away by the incredible work our students do and would really love to work with you next year and hope you enroll in our clinic. Thanks.
Okay, thank you. So the last clinic we're going to talk about is the Employment Law Clinic, and I'm the director of the Employment Law Clinic. And so I'm just going to give you a very brief overview and then turn it over to one of my students. There seems to be an echo. Okay. Anyway, so the Employment Law Clinic is one of the oldest clinics in the law school. It's so old that I was a student in it back when I was a student at the law school. Over the years, over the decades, we have changed our focus from working with clients in the state agency to legislative advocacy before the Illinois General Assembly, to what we're doing now, which is a mix of complicated federal class actions as well as a number of appeals. All of our cases are litigation cases, except for the small amount of legislative advocacy we do. And this is what I always call modern litigation, which means you have to know the federal rules of civil procedure. If you didn't like civil procedure, then this probably isn't the clinic for you. Or if you want to learn more about federal civil procedure, then this is the clinic for you. So, you know, we do lots and lots of discovery, lots of depositions, and then lots of briefing. Because it is kind of modern federal litigation, very few cases of ours go to trial. We have one that is set for trial, I think we'll see, currently for September. This is, I think, the third or fourth time we've been set for trial in this case. The judge really wants us to settle, and so keeps pushing the trial off. So with that kind of background, I'm going to turn it over to one of the 3Ls in the clinic, Michael Cardoza, to talk about his experience in the clinic. He joined the clinic as a summer student several years ago and has continued to work in the clinic to today. So Michael?
Hey everyone, I'm Michael, and I actually loved civil procedure, so it was a good fit. I'm a 3L, like Randy said, and I only have one class left in my entire law school career. I came into law school interested in working on the labor side of employment law, and so I knew that I wanted to be in this clinic before I even got admitted to UChicago. And I've had a chance to work on both of the sides of the clinic that Randy mentioned, the class actions and the appellate work. Now, the specific work that you're going to be doing in the clinic is going to depend a lot on what stage of litigation the case you work on is in. And so I'll go over some of the cases that I worked on and what I did in those to give you an idea of the work that you might be doing. So I've worked on a class action suit against a union for instituting a discriminatory hiring process. I've been on that case since my 1L summer, and it's gone through a couple different phases. When I first started, we had just received a decision on summary judgment, and we lost some claims, but then we also knew which claims we would be going forward with and likely going to trial. And so for prepping for trial, we went over and summarized old depositions. We reviewed documents that would be helpful in arguing the case. We did Daubert motions for the experts. We initially thought the case would be going to trial in spring of my 2L year, so we were preparing a 3L at that time. But then the trial date got pushed, and so we thought we'd be doing it in the fall of my 3L year. But over the summer while I was working at a firm, Randy and the summer students managed to make a lot of progress on a settlement. And so me and a 2L, Hill, spent most of the past year drafting and editing various documents needed for the settlement. And we've also been attending regular settlement conferences with the magistrate judge to kind of iron out the last couple issues. Now, I've also had the chance to work on 2 appeals in the 7th Circuit through the clinic. The first involved a former postal worker who was suing the USPS for intentional infliction of emotional distress. And I actually got a chance to do oral argument on this case in February of this year in front of the 7th Circuit. Before the argument, the appellate team and I worked on our opening brief and a reply brief to the response from the Postal Service. And in the lead up to the argument, we did 4 or 5 mock oral arguments, and I got help from all the other members of the clinics and a lot of clinical faculty doing moots, just like Andy mentioned in his talk. And the whole experience was really cool, and I'm really grateful for the opportunity and all the help that I received from everybody in the clinic community. Right now, I'm in the process of working to help prepare another student for her oral argument. In that case, we're amicus for a pharmacist alleging religious and country of origin discrimination against his former employer, as well as a religious failure to accommodate for refusing to give him prayer breaks. In about an hour, actually, we're going to be doing our first live mock argument. Because of the pandemic, the argument is going to be conducted over the phone, which is going to be kind of weird, but I know that Deanna is going to do a really good job. There was one last appellate case that I didn't work on, but I thought it was really interesting. I wanted to kind of share the story of Angela, who's another 3L. She led a mediation effort that ultimately ended in settlement of the dispute. She got to give an opening statement, and then the 2 sides went back and forth. And in that process, she had to convince the other side that they had a real risk involved in going to trial. She had to convince the mediator to kind of push the other side to give more money. And she also had to convince the client so that he would agree to a compromise. Lastly, I just wanted to say how much I enjoyed my time working in the clinic for the last 2+ years. I learned a lot more about being a lawyer working with Randy than I did in any of my classes. And I want to emphasize how great all of the clinical experiences are, and anyone that's considering it really should go ahead and just do it. And if anyone has any additional questions or just want to talk about my experience, go ahead and shoot me an email at mcardoza@uchicago.edu. Thanks.
Okay, thank you, Michael. So that kind of wraps up the presentations by the various clinics, and we still have, I'm very happy to say, some time for questions. So what I'm going to ask you to do is raise your hand using the blue, raise your hand button, and I will see if I can find people who raise their hand. Any questions? No, no questions. So I put up on, oh, wait, Marissa.
Hi, I was just wondering if you know how many clinics we're allowed to bid on when enrolling for classes?
I believe well, there are a couple things about that. I believe you're allowed to bid on more than one, but there are special rules about which clinics you can work for at the same time. Because a number of us are treated as separate entities and our conflict of rules prohibit, attorneys' conflict rules prohibit us from working in those two clinics at the same time. So I believe those rules are in the handbook. And earlier I posted on the chat kind of the rules for all the clinics, and I think that should be there, but I do believe you're allowed to bid on more than one. Other questions? So let me ask you, on the chat, did you see the various rules for all of the clinics? Are they there? Anyone who has their camera working, you can nod. Okay. So do any of the faculty have anything else to add?
I would, if it's okay,
Yes.
I would just add, since we have time, you know, FCJC also does represent, sorry, I hope you can't hear the helicopter in the background. FCJC does also represent indigent clients on trial level federal felonies. And so that's sentencing, appeal, and of course, the trial itself. Those can be cases where we're appointed by the court or also where we collaborate with another attorney. In recent years, in fact, separate teams of FCJC 3Ls have prepared for 2 federal felony trials where students really played a critical role. Students drafted all the pretrial motions and got some unheard of results. One team's Fifth Amendment motions were actually so persuasive that the government just gave up. They just agreed not to introduce our client's statements at trial. After that, we developed trial strategy, questions like, why was our client not guilty? What evidence could we use to show that? We analyzed the government's witnesses. Why were they lying? How could we persuade a jury? And we also developed examinations for all of the important witnesses. So we actually had a trial scheduled for this spring until, you know, there was a global pandemic. So that's been rescheduled to next fall. And assuming it happens, that'll be a fantastic opportunity for next year's 3Ls. So I just wanted to throw that out there. Thanks.
Thank you. So I don't see any other questions. So if there aren't any other questions or no other comments from the faculty, I think I'll just end this meeting. Oh, Mark.
Yeah, I'll just say one thing particularly directed to first-year students, which is that I know sometimes in the first year, you can be in larger classes or your classes that are not the, you know, you've got the Bigelow seminars, but you can be in larger classes and wonder about, you know, how am I going to develop opportunities to work really closely with faculty? That's what the clinics are. I mean, we know our students well, they know us well. There's nothing quite like working on these projects and the ups and downs of them for our clients. And I maintain connections with most of the students that I've had in the clinic through the years. We're committed. I feel comfortable saying this. You know, we're here as opposed to being at other places like NGOs because we really care about the teaching. We really care about you, and so we really want to work with you. And the last thing I'll just say is, please reach out to us. If you might be interested in this clinic, great. If you might be interested in another clinic, great. We can help, you know, if we hear about your interests, we can help talk about what are the best clinics for you to be in too. So please, we are really looking forward to working with you this coming year.
Okay, thank you everyone for attending, and I hope to see many of you, if not all of you, in a clinic next year. Take care.